Stephen Miller, the White House Deputy Chief of Staff, announced on Friday that the Trump administration is considering suspending habeas corpus, which is the right of individuals to challenge their detention in court. If President Donald Trump proceeds with this action, it would mark a significant intensification of his administration's immigration policy by greatly limiting a right that is enshrined in the Constitution. During a conversation outside the White House, a reporter asked Miller when such a suspension might occur in the future, given President Trump's previous discussions on the matter as a solution to illegal immigration. Miller responded by stating that the Constitution clearly allows for the suspension of habeas corpus during times of invasion, indicating that it is an option the administration is actively considering. The Constitution permits the suspension of habeas corpus under extraordinary circumstances such as an invasion or rebellion, when it is deemed necessary to protect public safety. Historically, the United States has suspended habeas corpus on 4 occasions: during the Civil War, during Reconstruction in South Carolina, in the Philippines during a 1905 insurrection, and in Hawaii in 1941 following the bombing of Pearl Harbor by Japan during World War II. Miller justified the potential suspension by arguing that the United States is currently facing a national security threat from undocumented migrants invading the country. A similar rationale was used by Trump in March to invoke the Alien Enemies Act, a law allowing for the rapid deportation of non-citizens with minimal due process, to expel alleged members of the Venezuelan gang Tren de Aragua. However, 2 federal judges, including one appointed by Trump, ruled that using the Alien Enemies Act was unlawful because the administration failed to prove that the United States was being invaded by Tren de Aragua. Miller indicated that the administration's decision would depend on whether courts do the right thing or not. Legal experts, however, argue that the issue is not as straightforward as Miller suggests. They emphasize that a president cannot suspend habeas corpus without Congress's authorization. Georgetown University Law Center professor Steve Loddick noted that there is a near universal consensus that only Congress can suspend habeas corpus, and that unilateral suspensions by a president are unconstitutional. Loddick further explained that Miller seemed to suggest an unlawful suspension of habeas corpus if the administration disagreed with court rulings. He pointed out that judicial review itself is not endangering national security. Rather, it is the possibility of government loss that is being framed as a threat. This, he argued, has never been a valid reason for suspending habeas corpus. President Abraham Lincoln famously suspended the writ of habeas corpus at the start of the Civil War. However, then Chief Justice Roger Taney declared this move unlawful, noting that the relevant clause is found in Article I of the Constitution, which outlines Congress's powers rather than those of the president. Lincoln eventually saw congressional approval for the suspension as the war continued.